can I ask you a question about whether you have to go to 2255 first or whether you can go straight to the compassionate release statute? You answered when the Chief was asking you questions. In that interchange, you suggested that the prisoner would have to go to 2255 first because otherwise it wouldn't be a compelling circumstance for release. So are you reading kind of an exhaustion requirement into compelling so that someone in your client's position would have to try to get relief through 2255 first before invoking this other procedure, or no?
No, Your Honor, that's not our position. Our position is that as part of the extraordinary and compelling analysis, courts would consider whether a defendant sat on his rights or whether he's taken all opportunities to enforce his rights. Even if a defendant did not go through 2255, he would still have the option to argue under 3582 that his situation is extraordinary and compelling, but his position would be weakened by the fact that he did not take the opportunity to enforce his rights.
Why would you ever bother with 2255? It seems like it would be a lot easier to just go the other route as long as you have some other circumstances to invoke.
Well, for the first reason would be that 3582 sets a very high bar for defendants. It has to be extraordinary and compelling. Also, the relief that a defendant can obtain under 3582 is limited. He can only reduce the sentence, whereas the relief under 2255 is much broader. He can attack his conviction. Also, there will be plenty of errors where a court will not feel comfortable simply releasing somebody, but rather would want to correct the error by remanding by having a new trial.
But a First Step Act error, I mean, you've made the position, and it's true, Congress changed it because those sentences were extreme, right? They were extremely long. And it seems to me that if indeed that's extraordinary and compelling, the disparity between similarly situated defendants who get the benefit of the act and who don't, I mean, why wouldn't that be extraordinary and compelling on its own terms? And plus, you know, there are downsides, too, to attacking the validity of your conviction, because then you could be subject to retrial.
That's right, Your Honor. And it certainly can be extraordinary and compelling. But to date, courts have interpreted the phrase narrowly. There have only been, by our count, 12 cases since 2018, when the First Step was enacted, where a court, based on an argument that could have been raised on 2255, in part granted a sentence reduction. So courts have been using this very infrequently to grant relief.